Losing a loved one is undeniably one of life's most challenging experiences. Amidst the grief, families often face the daunting task of navigating complex estate matters. One of the most critical legal processes you will likely encounter is probate. But what exactly does probate mean when there is already a will in place? In this video, we will break down this process step by step, providing you with clear, actionable information so you know exactly what to expect. The information in this video is for educational purposes and is not legal advice. Always consult a qualified attorney. Let's get started. Let us start with the big question. What exactly is probate? In simple terms, probate is the formal legal process of validating a person's last will and testament. During this time, the court oversees the inventorying of all estate assets, ensures that outstanding debts are paid off, and then legally distributes what is left to the rightful beneficiaries. Why is this legal oversight necessary? There are 4 core reasons. First, the court must validate the will to confirm it is authentic. Second, probate protects the assets from unauthorized access. Third, it provides a structured process for resolving outstanding debts and taxes. Finally, it ensures a legal transfer of ownership to the heirs. Going through probate with a will is known as dying testate. Your will acts as a clear roadmap, making the process straightforward and less stressful for your family. Passing away without a will is called dying intestate. State laws then decide who gets what, turning probate into a long, complicated maze. Ultimately, having a solid will simplifies the entire legal process. When a will enters probate, 3 key players take the stage. First is the executor. Named in the will, they are responsible for gathering assets, paying outstanding debts, and managing the estate. The executor carries a strict fiduciary duty, meaning they must act solely in the best interest of the estate. Next are the beneficiaries. These are the people or organizations chosen to inherit the assets. Beneficiaries have the right to receive regular updates about the estate and possess the legal standing to challenge the executor if they suspect any mismanagement. Overseeing it all is the probate court. The judge validates the will, officially appoints the executor, and monitors the administration. The court ensures that the process is fair, legal, and that the deceased's final wishes are accurately honored. Navigating the probate process with a valid will involves a highly structured legal journey. The first step is crucial. The original will must be filed with a probate court clerk in the county where the deceased lived. Along with the will, the nominated executor files a petition for probate. This formal petition requests the court to open the estate and officially begin the legal proceedings. Once the petition is filed, the court requires that formal written notice be given to all named heirs, beneficiaries, and known creditors, giving everyone a chance to participate. Simultaneously, the probate court will review the will to validate it. The judge ensures the document meets all state requirements, which typically involves verifying the proper signatures and reviewing witness testimonies. After validation, the court officially appoints the executor named in the will, granting them letters testamentary. This powerful document provides the executor with the legal authority to manage the estate's affairs. Armed with this authority, the executor's first major task is to identify, gather, and meticulously create a comprehensive inventory of all probate assets, assigning accurate date-of-death values. Before beneficiaries receive their inheritances, the estate must settle its financial obligations. The executor uses the estate's funds to pay off legitimate debts, final bills, and any outstanding taxes. Only after all these financial obligations are completely cleared can the remaining assets be safely distributed to the designated beneficiaries, exactly as outlined in the deceased's will. Finally, once all debts are paid and assets distributed, the executor submits a detailed final accounting report to the court. If everything is in perfect order, the judge approves the accounting, discharges the executor from their duties, and formally closes the estate. Keep in mind, these specific steps and timelines can vary significantly from state to state. Even with a will, probate is not instantaneous. The timeline can vary dramatically. For a relatively simple estate, the process might wrap up in 6 to 9 months. However, more complex estates can drag on for a year or much longer. Several factors can throw a wrench into the timeline. If someone contests the will, if there are complicated creditor claims, or if the estate triggers a tax audit, you can expect significant delays. And then there are the costs. Probate isn't free. You'll need to account for attorney fees, which could be hourly, a flat rate, or a percentage of the estate. Add to that executor fees, court filing costs, and potentially appraisal fees for property. Let's look at an illustrative example from California's statutory fee schedule. For a $500,000 estate, the statutory attorney fee would be $13,000. This is just an example, as fees vary wildly by state, so always check local laws. While probate is a standard legal process, there are highly effective strategies to simplify or bypass it entirely. It all starts with comprehensive estate planning. Sitting down to craft a well-drafted will provides clear instructions, greatly reducing confusion and delays for your heirs. Another powerful tool is joint ownership with rights of survivorship. With this designation, the asset automatically transfers to the surviving owner upon your death, completely skipping probate. Establishing a living trust is a popular way to avoid probate. Assets placed inside are managed by a trustee and transferred directly to beneficiaries without court approval. Utilizing beneficiary designations is also crucial. Life insurance policies and retirement accounts let you name direct beneficiaries, so these assets pass straight to them, sidestepping the court. Finally, if your total assets fall below a specific threshold, your heirs might qualify for small estate procedures. This simplified estate process saves significant time and legal fees. Even with a carefully drafted will in place, the probate process is not guaranteed to be smooth. Disputes frequently arise. Aggrieved family members might contest the validity of the will, bringing allegations such as a lack of mental capacity, undue influence, or even outright fraud. Beyond family disagreements, estates often face external pressures like aggressive creditor claims demanding payment from the estate's assets. Furthermore, beneficiaries might raise serious accusations of executor misconduct if the estate is mismanaged. Navigating these highly emotional legal roadblocks requires expertise. Because of these potential landmines, seeking qualified legal assistance is absolutely critical. An experienced probate attorney can navigate these complexities, advise you on your legal rights, represent the estate in court, and resolve bitter disputes, ensuring the estate administration is handled properly. Navigating the loss of a loved one is never easy, and dealing with the legalities of probate on top of that can feel overwhelming. We hope this guide has brought you some much-needed clarity on what probate means when there is a will. We covered everything from understanding the executor's vital role and the step-by-step court process to managing costs and handling potential challenges. If you found this information helpful, please give this video a like, subscribe to our channel, and hit the bell icon so you never miss an update. We also invite you to share your experiences or ask questions in the comments below. For more resources, detailed guides, and support to help you through this journey, please visit probateus.com. Thank you so much for watching, and remember, you do not have to navigate this process alone. Take care.